State your name.
I'm Shane Scott, I'm a Weedon School alumnus from Reno High.
I'm Leslie Brian Carter, I'm the attorney at Reynolds Freedom College.
I'm Richard Bryan, and I'm Leslie's father.
I'm Carter Stewart, and I will be attending the University of North Texas.
I'm Tommy Bergsbank, and I will be attending the University of Southern California.
My name is Kelsey West, and I will be attending San Diego State University.
Hi, I'm Jacob Wade. I haven't decided where I'm going yet. It's between University of Arizona and University of San Diego. Our unit coach is Scott Daniel, and our teacher is Mr. Clark.
Unit 5, you concentrate on what rights does the Bill of Rights protect? Your question is number 2. What are the primary similarities and differences between the free exercise and the establishment clauses of the First Amendment? Should organizations that oppose certain requirements of the Affordable Care Act because of their religious beliefs be required to comply with that law? Why or why not? Compare the First Amendment's free exercise and establishment clauses to Article 18 of the Universal Declaration of Human Rights. How are they alike? How are they different? You may begin.
Individual equality, government scrutiny, and declaring individuals the freedom to practice are the primary similarities between the free exercise and the Establishment Clause of the First Amendment. The clauses allow all citizens to have the opportunity to practice any religion they choose without discrimination or government interference. According to the broad interpretation of the Freedom of Religion Clause, the government is completely separate from religion, making aid to any religious group besides necessary assistance unconstitutional.
These clauses invoke individual equality, especially since they guarantee that an individual has the freedom to participate in whichever religion he or she decides to believe in. Individual equality is also exemplified through the different interpretations of the freedom of religion clauses. None of the interpretations grant the government the ability to deny one particular religion certain aid while providing aid to a separate religion. The primary difference between the free exercise and the establishment clauses are the enumerated rights given to individuals in the clauses.
In Smith v. Oregon, 2 Native Americans who worked at a private drug rehabilitation organization used peyote as part of their religious ceremonies and were fired. They believed the Oregon drug law violated the free exercise clause of their right to freedom of religion. Justice Scalia held the majority opinion that an individual's religious belief do not excuse him from complying with a law prohibiting conduct, since the government has the power to regulate it.
The neutral law of general applicability relates to the free exercise clause in that everyone is under the same law and religion does not take precedent. This neutral law can be implemented to the Affordable Care Act as it was in Smith v. Oregon. Despite the church's belief that withholding contraceptive pills is in line with their right to free exercise, it is the action they are taking that no longer falls under the free exercise clause because their beliefs have now turned into actions.
Organizations oppose Section 2707B of the Affordable Care Act, that religious beliefs should not be required to comply with the law, as it is an implied infringement on the group's religious freedom. The free exercise clause clearly limits the government from punishing someone for their religious beliefs. Under the law, churches and houses of worship are exempt from the mandate, but other non-profit religious affiliated groups such as church-run hospitals, parochial schools, and certain charities must either provide no-cost contraceptive coverage or have a third-party insurer provide separate benefits without the employer's direct involvement.
These groups should not be exempt because their employees are tied to various religions or have no religious affiliation at all. However, there are competing religious organizations that are on both sides of the Affordable Care Act's contraception provision. While the Little Sisters of the Poor opposes Section 2707B, the National Coalition of American Nuns is defending it, stating, "We know that religious freedom means that each person has the right to exercise their own religious beliefs. But religious freedom cannot mean that an individual or a corporation gets to impose their religious beliefs on their employees."
The value of religious freedom is not unique to the United States. Article 18 of the Universal Declaration of Human Rights emulates characteristics of the First Amendment by preserving religious freedom for the rest of the world. The Declaration protects the freedom to practice and believe in any religion, just as the first Congress intended the First Amendment to function. However, differences arise when you look at the historical background for the two documents. The UDHR was written at the conclusion of World War II, when the world was rebuilding and the horrors of the Holocaust were uncovered.
In addition to religion, freedom of thought and conscience were also mentioned in Article 18. As the writers of the UDHR found freedom of religion alone did not protect the rights of humans through the course of history. Article 18 and the Free Exercise Clause try to give all persons the freedom they deserve with as little governmental interference as possible. Thank you.
As I think you know, I sit in the family court, so this question is one that is of particular significance to me. Does marriage fall under the free exercise or the establishment clause of the Constitution?
Marriage falls under the free exercise clause as it was established prior to government. It was established by religion. So every religion practices marriage differently. So it falls under the free exercise clause in that sense.
I would disagree with Carmen. It's part of the Establishment Clause because in the United States, in order to have a recognized marriage, you have to have a marriage license. And that goes for all different religions, even if you don't want to have any religious affiliation with your marriage license at all. So marriage would definitely go under the Establishment Clause as it has to be universal to get that marriage license.
I would have to agree with Tommy that the marriage falls under the Establishment Clause, but in the sense that marriage differs in different religions, and the United States cannot establish a definite religion, so by not just establishing a definite religion, they can't have a definite definition of marriage.
Adding on to what Carmen said, recently the Arizona governor vetoed a bill that would have allowed all businesses to deny customers service due to their sexual orientation, and the customers were claiming that it was their free exercise clause, their right to free exercise involving this case with marriage.
Do you think the negative rights in our Constitution are more effective than the positive rights in the Universal Declaration of Human Rights? Why or why not?
The negative rights in our Constitution are far more important than the positive rights in the UDHR, as the negative rights we use are utilized far more often, such as in First Amendment freedom of religion and freedom of speech.
You also have to look at the fact that the negative rights in our Constitution, specifically in the Bill of Rights, are implemented on a day-to-day basis, and they have enforcement power. As opposed to the UDHR, it's just a declaration of rights, so there's no real enforcement unless separate governments that already have established governments decide to act upon it.
Along with this declaration in relation to not having enforcement power, with the Constitution, the Bill of Rights, and the negative rights that it protects for the people, it also allows for judicial review and Supreme Court cases to make new laws and even legislation to protect the people even further.
What role, if any, should the government play in fostering or limiting religious diversity?
Well, there are three interpretations of the right to freedom of religion. One being the broad interpretation, where the government shouldn't have any interference unless it's necessary, such as if there's a fire in the church. And it allows for church and state to be separate. So this is just one example of the question we were talking about.
However, we can see this governmental interference in the diversity of in the education system. For example, when we put into place the affirmative action plan, it made it possible for schools of higher education to have their applicants cite what race they are and where to get a little more background of who they are as a person, so they can increase this general diversity in their schools, which they believe will help the education of their students.
As we see with the Lemon test, government interference with religion must have a secular purpose, and so government interference with religion must be prohibiting certain, or,
My question is, what relevancy does Article 18 of the Universal Declaration of Human Rights have to our discussion of constitutional rights? The Bill of Rights is a part of our Constitution. The Declaration is not part of our Constitution. Laudable as those objectives may be, does it have any relevance in terms of our constitutional rights? Should it be cited for authority for any proposition that is derived from the constitutional rights that we enjoy?
It does have relevance to our rights as American citizens. The Article 18 of the UDHR has huge similarities with the freedom of religion clause in the First Amendment, and the difference between the two clauses is that the UDHR goes into much more depth about what religion is and how we can defend that, as we saw, as it was coming from a time when there was mass genocide of one specific religion and there was huge atrocities going on. So we saw that it was more needed in that place than it was in 1776 when we wrote the Constitution.